All right, pause right here, because this case starts deceptively calm. Ariana Evans is already on probation, which means the court's patience is thin. Every word from this point on matters, and one wrong move can flip probation into jail time real fast. Watch closely how this judge listens.
Are you Ariana Evans?
Yes, ma'am.
And this is 22-41163, and Miss Evans is currently on probation for a lesser offense of terroristic threat against a public servant, a Class A misdemeanor. And previously in court, entered pleas of true to counts 2, 3, 4, and 5. I received an updated pre-sentence report. Has everyone had an opportunity to review that report?
Yes, sir. Yes, sir, I have.
Are there any additions or corrections?
No, Your Honor.
I'm sorry, Your Honor.
Yes, ma'am.
The GPS device, I was just emailed Friday, 5:43, that it's been dead, the battery's been dead for 3 days.
Okay.
And there it is, the GPS device. In probation world, a dead battery isn't a technical issue. It's a red flag. Courts often see this as avoidance, not accident. Question for you. Do you think this was neglect or intentional?
Okay. Thank you, ma'am. Mr. Kimler?
Well, Your Honor, recommendation obviously is not favorable to Ms. Evans. I mean, they do provide an option that if the court does consider maintaining her own probation.
Well, she doesn't want that.
Sir?
She doesn't want that, right? I mean, it says right here she just wants to do her time so she can move on with her life and put the case behind her.
Yeah, I mean, if I like get a chance to like get reinstated on
Which deeds? What do you want?
if I can do the 60 days that they offer me and be off probation.
60.
This moment is huge. She thinks she still has options, but once the judge says it's up to me, the negotiation phase is over. Probation isn't a menu. When you reject supervision, you're usually choosing jail without realizing it.
60 days is off the table. So that's what the state offered, I think, before. Y'all are unagreed. It's up to me to sentence you today. So,
Okay, so
What-
I already be reinstated.
okay.
It is a misdemeanor.
I understand. Go ahead.
And obviously, the easy way for her to address this situation is to take the revocation and take jail time. However, the defendant's version does indicate some mental health issues. Obviously, probation is a system designed to try to keep people out. Actual criminal justice system in the future and what incarceration. So, just looking at this as it is just a misdemeanor, I would suggest, just in her interest, and perhaps in the interest of the community, that she continue to follow maybe the recommendation you adjudicate with 30 days up front, or no upfront time, but the mental health component be addressed with Ms. Evans to see if she can make progress with her so-called cordial attitude, which I think under the DSM may be diagnosed as an antisocial personality disorder, whatever her issues are.
Did you see that somewhere, or did you just make that?
Well, I think
Notice the shift here. Mental health is being mentioned, but without diagnosis or documentation, it becomes a weak shield. Judges are careful. Sympathy without proof doesn't override repeated violations. This is where defense arguments often collapse.
that if they're saying she's incorrigible, I mean, obviously I'm not a mental health expert.
Okay. I just didn't know. I didn't see anything
She has
where she
no-
was diagnosed.
She has been diagnosed.
Okay.
There's probably some issues there.
Okay.
Obviously, things that can be dealt with.
Judge, I think in court it wanted to find me, she doesn't want to do probation, doesn't want to be done, what you can and can't do, I'd ask you for over.
So, Ms. Evans, I mean, you were given, number one, you were given a great opportunity because you had a felony and they reduced it to a misdemeanor and put you on probation for 2 years. It looks like they gave you all types of help through JCDI, and you failed to complete your groups, didn't obtain a sponsor, you were tested positive, you were ordered to the Franklin North so that you could get some more intense help. You did okay in that, and then you got out and started struggling again. You You were also ordered to go to Spindle Top for mental health treatment so that you could get the help that Mr. Kimler is saying that you might need. And looks like they say you attempted to circumvent the requirements to obtain a sponsor. Your sister pretended to be your sponsor. You were placed on zero tolerance in JCDI. You tested positive for alcohol. You left the state without permission.
This is the avalanche. Failed programs, positive tests, fake sponsor, leaving the state. Individually, some of these might slide together. They paint a picture of total noncompliance. At this point, probation is basically indefensible.
I mean, all right, I'm going to find that you entered your pleas of true to counts 2, 3, 4, and 5 freely and voluntarily. Find those counts true. Find sufficient evidence to find you guilty, and at this time find you guilty of the Class A misdemeanor of terroristic threat against a public servant. I'm going to sentence you to a term of 180 days in the Jefferson County Jail. You will receive credit on that sentence for any time that you were previously in custody that the law gives you the right to receive. I'm going to hand you the trial court certification that shows this was not an agreement. You do have some rights to appeal. Y'all need to sign that real quick, please, Mr. Kimler, and give her that bottom copy.
That sound right there says everything. Sentencing has landed, reality has hit, and there's no rewind button. Final thought. Do you think the judge was left with any real alternative here, or was this outcome sealed long before today?
And he'll give you that copy of that, and then you can go with the bailiffs.
Thank you, Your Honor.
Thank you. Thank you, ma'am. Talk to the bailiff. Just talk to the bailiff.